Laura Little, the James E. Beasley Professor from Temple University Beasley School of Law, will be speaking first. Her title is Empowerment Through Restraint, Reverse Preemption, or Hybrid Lawmaking. Our second speaker is Robert L. Glicksman, the Robert W. Wagstaff Distinguished Professor of Law from the University of Kansas, who will be speaking on access to courts and remedial preemption and collective action perspective. And finally, our third speaker is Case Western's own Jonathan Etten, who is Associate Dean for Academic Affairs and Professor of Law and Political Science. And he'll be speaking on preemption in the states, on the meaning and limits of home rule. And at the end of the three speakers, we'll have time for questions from the audience.
I'm delighted to be here and to follow such a wonderful panel. I'm actually going to change the channel quite considerably. To the extent that I connect with the previous panel, I'm going to flip it and talk about what one could say is reverse preemption, but I'm also going to change the focus. That is, I'm very much going to concentrate on two specific cases from the Roberts course from the last two terms. As students of federal jurisdiction, we often see federal courts empowering themselves under the banner of deference to state prerogatives. I'm going to explore two examples of this and continue the idea of strange bedfellows, but my strange bedfellows are my examples. On one hand, I'm going to look at a foreign relations case, and on the other hand, I'm going to look at a bankruptcy case, all right? So we're going to be embracing foreign relations and bankruptcy together. And in both contexts, the Roberts Court acted under the banner of sort of deferring to state prerogatives, but it bestowed on itself ultimately considerable control, and lower federal courts considerable control over the ultimate outcome of the disputes. And this is something we see often, you know, abstention being a good example, standing being a good example. We see the court do it with habeas corpus doctrine as well. But I want to expand my focus to not only talk about sort of the reverse preemption aspect of the cases, and also talk about the court's empowerment of itself, and but also conclude with some observations about how the court actually engaged in hybrid lawmaking. So that's a tall order, right? Hybrid lawmaking, empowerment, and reverse preemption. My foreign affairs illustration is the Medellin case, Medellin versus Texas, the 2008 decision. You could take a number of angles on the case. I have a colleague who claims she's interested in all things Medellin, and I guess she's going to spend the rest of her career, you know, talking about that case. I just take a specific angle on it with respect to the choice of law issue in the case, the choice between state procedural default law on one hand and an international tribunal's interpretation of the U.S.'s treaty rights on the other hand. My bankruptcy illustration is a 2007 decision, Travelers Casualty Company versus Pacific Gas and Electric, which put into effect or expanded on an earlier, more famous case, at least in bankruptcy circles, Butner versus United States, which presents a choice between state and federal law. In terms of the issue as to whether or not the conservatives on the Roberts course are being hypocrites or consistent with other forces that they might be acting on. I want to sort of suggest that they're really, in some way, although there may be some irony in that the result of a lot of these preemption cases is to give effect to federal authority, we should be sort of careful in our analysis of precisely what's dominating, because dominance can come in both positive and negative forms. And I would suggest that in the illustrations that I'm going to look at, that even though the Roberts Court sort of gave precedence to state authority, that it maintained for itself a great degree of dominance. And my focus is on methodology, in large part, in sort of trying to understand how it is that the court maintained control. But I'm hoping also that I have a message for a debate that's raging both in the Supreme Court and in the law review commentary. Seems to be a very long-lived debate about the wisdom of the use of foreign and international principles in domestic decision-making. Okay, so let me give you a brief description of my two contexts. Medellin is probably the better known of the two. It's an enormously rich case with separation of powers implications, treaty interpretation, et cetera. But as I said, I want to look at the clash between state law and the international decision in the case and see how the court analyzed that. Medellin was a Mexican national. He was a death row inmate in Texas. He had not been apprised at the time of his election, at his arrest or his trial, of his rights under the Vienna Convention for Consular Relations, of his right, in fact, to consult with his home consulate. In related litigation around the same time, the International Court of Justice had, in fact, held that the individual states of the United States have obligations under the Consular Relations Treaty, and that, in fact, individuals, including Medellin, had a right to a reconsideration of their sentence and convictions. After the International Court of Justice made this ruling, President George Bush, in a memorandum to the Attorney General, stated that the U.S. would discharge its international obligations by having the state courts give effect to this international tribunal's decisions. Medellin responded by filing a petition for writ of habeas corpus in the state courts. Ultimately, the Texas Court of Criminal Appeals dismissed the writ, citing abuse of the writ, citing his procedural default. He had never raised the claim based on the Consular Relation Treaty in his earlier proceedings. The United States Supreme Court affirmed, right? The United States Supreme Court said that state procedural default law should not yield to the International Court of Justice's interpretation of the obligations of the U.S. under the treaty, nor should state procedural default law yield to the President of the United States and his understanding of obligations under international law. As to the International Court of Justice judgment, the court stated that state procedural rules are so inviolable that, in fact, basic rights guaranteed by our own Constitution do not have the effect of displacing state rules. As for the president's power, the court stated, and here we have a real states' rights flourish, that the president's power does not reach deep into the heart of the state's police power and compel state courts to reopen final criminal judgments. My bankruptcy tale, changing to the odd bedfellow, the bankruptcy tale begins with Erie, and the uncertainty after Erie as to whether or not the presumption in favor of the application of state law has any role to play in bankruptcy. There had been sort of conflicting decisions on the wake of Erie, conflicting law review commentary. In 1979, in a case, Butner versus United States, the United States Supreme Court tried to clarify the question, basically saying that the presumption that state law should apply, should govern in bankruptcy proceedings, at least for the purposes of property rights. The court said that property interests are created by state law, and there's no reason, as a general matter, why obligations and interests under state law should change simply because one of the parties involved in a bankruptcy proceeding. But the court had an escape hatch. That is, it said that unless some federal interest applied, this presumption in favor of state law should govern. Now, the 2007 case, the Travelers case, applied this principle in the context of a contract dispute. Travelers was trying to actually get some attorney's fees paid back for litigating its claim in bankruptcy. There was a clash between federal common law on one hand, federal common law of bankruptcy, you might say, that said that where in fact a party was litigating its interest in bankruptcy, it couldn't recover attorney's fees under a contract, and contract law, on the other hand, which would, of course, sort of generally honor the term of the contract, providing for attorney's fees that the debtor had agreed to pre-petition. The court, looking at this question, resolved it, applying this presumption in favor of state law, saying that there was really no indication that this common law rule that had been kicking around should apply. But again, it left an escape valve, an escape hatch, and it said, we express no opinion as to whether other principles of bankruptcy law might provide an independent basis for disallowing the claim for attorney's fees. In other words, there might be some federal bankruptcy interest out there that might point to another conclusion. Well, it turns out that the lower courts quickly took the invitation to find that federal bankruptcy interest. It was implicit; they didn't point to any particular provisions in the bankruptcy code, but they've in several cases they've actually applied this federal common law rule. Okay, so how is it that these cases are at all connected? Obviously, they're from very diverse contexts with many different diverse factors that sort of give the meaning. But I think it's important to note that, in fact, in both instances, the court allowed state law to dominate, as it were, but under circumstances where it maintained very, very careful control. That is, the terms of engagement with the state law was very much federal judicial terms. What type of approach did the court use? Did it use a rules-based approach or a standards-based approach, right, to maintaining control? Well, I think from the point of view of travelers, it's pretty clear that the court used, sort of the type of balancing, free-flowing, we might find out there post hoc some federal interest orientation towards the problem. That is, I would say that travelers used what typically is thought of as a standards-based approach with flexibility, looking to policies that may actually give a different resolution than we might ultimately, originally have thought if we were to formulate a legal regulation. Medellin, on the other hand, by contrast, looks very rule-like, right? The court was categorical. That is, as though there was this impenetrable domain that states that the state's interest in the criminal law and the finality of criminal justice lived, and that the President of the United States, an international tribunal, nothing could penetrate this. But if you think about it in terms of the greater context of state procedural default and the circumstances under which in federal proceedings, procedural defaults are evaluated, you see that actually there's a fair amount of flexibility to what the Roberts Court set out. That is, in terms of federal jurisdiction doctrine, when there's a claim of federal procedural default, there is a huge body of federal law which evaluates the circumstances under which a state procedural default will or will not be honored. If you think about direct review to the United States Supreme Courts of cases coming up through the state court system, in order for the state procedural default rule to be given effect, it must stand as an independent and adequate state ground for the decision. And in a series of cases, the Supreme Court has been very critical in evaluating whether or not the state procedural rule merits that kind of deference. There have been circumstances dealing with, like the Supreme Court smelled a rat look like the state court might have sort of made up the rule for this particular litigant. It asks, is it novel? Is there a factual basis for saying that the litigant actually didn't raise the particular claim? There's a whole line of cases dealing with sort of a power struggle with the NAACP and the Supreme Court of Alabama in that regard. So that there's actually a lot of federal scrutiny as to whether or not to give effect to the procedural default on direct review to the United States Supreme Court. Likewise, review on habeas corpus has a federal element to it, to the extent that the courts will evaluate, is there cause and prejudice? The Anti-Terrorism and Effective Death Penalty Act of 1996 has all sorts of standards, at least with respect to death penalty petitioners, as to whether or not this procedural default recognized under state law will be honored. Now, there's another observation that I might make about these two contexts. I'm actually still trying to work out whether it makes any difference, but the way that federal law operates with respect to state law is very different. If you compare Medellin to the bankruptcy cases. If candy metaphors are of any help, in the procedural default context, you have state law, right, that's being honored, and that's the center, right? But before we actually give effect to the state procedural default law, it has to get through a federal coding. I mean, and we could debate whether it's like a easily pierced M&M type coding or a more, sort of difficult to crunch Tootsie Pop type coding. But all that is very different than what you see in bankruptcy, where in fact there's like all sorts of different places, sort of permeating the state law, where there might be this indistinct, implicit federal interest in the bankruptcy code. It's almost as though, you could think about Nestle Crunch bars, where there's like lots of different elements, I guess it's Rice Krispies, or Pop Rocks, it's like it's sort of exploding federal interest, right, which dominates the particular the particular inquiry. Now that I'm talking about like exploding federal interest, it sounds like I might be like maybe overstating my case a little bit. That is, I don't want to suggest that the court here is the ultimate consequential actor. Right? That is, there are other entities that may very much sort of influence the bottom line. Congress could step in, right? Congress could say, we're going to pass a bankruptcy code provision that regulates this precise instance, or it could step in with regard to implementing treaty provisions. Or in the context of Medellin, actually, we have the state and local entities checking in. Ultimately, the Texas said that it would actually honor the International Court of Justice decision, as did Oklahoma. But the point is the court is still controlling the doctrine, right? And it's doing so in a way where it's very much meshing state and federal law, right? So one of my points for, just as a greater observation when it comes to evaluating preemption is, don't forget, whether you're talking about reverse preemption or affirmative preemption, is that there's lots of instances really where we have a hybrid regulation that's going on. Federal jurisprudence brims with examples. You'll have common law examples, let's say with maritime law, where state law provides significant details about property rights. Or you'll have federal statutory examples where state law is filling the interstices. That is, whether, if you take, for example, CERCLA, looks to state law for guidance on corporate successor liability. So state corporate law is integrated into the federal law scheme. My research assistant was delighted when I sent her to look at federal tax lien cases, where you have this sort of interplay between state law and the federal tax code. Section 1983 litigation, right? We have to look at state law with respect to customer policy. In addition, we have constitutional due process, right, where you have layers, strata of state and federal law. You have federal law saying what processes do, state law saying whether there's a liberty or a property interest, but you have a federal, like, sort of eyeglass in evaluating that state law, et cetera. And finally is, just as an example of how pervasive this is, we have SOSA from a few terms ago, where the United States Supreme Court invited federal courts to look to international law in giving effect and meaning to the Alien Tort Statute. And that, I think, brings in, I guess, what might be one of my final points. And that is, might there be a message from all this for the debate about integrating transnational and international principles in constitutional decision-making? I mean, for those that are, regular readers of the Advanced Streets or the Law Review articles, that sort of touches a very delicate nerve. Perhaps you remember the 109th Congress even did an attempted jurisdiction strip, preventing federal courts from consulting the laws of other nations, except for those connected to the common law of England, as well as international law in constitutional decision-making. The justices are particularly shrill in commenting on the propensity of their colleagues to look to international and transnational principles. And one of the many different explanations for this, one of the ones that actually was very intriguing to me and I think resonated, was Justice Breyer's idea, was that really his colleagues aren't so upset about the use of foreign law or international law in decision-making, but they're displacing. What they're really upset about is the bottom line of these cases, and that it's their anxiety is sort of getting tied up with the idea of losing federal identity. This idea of anxiety, I think, tends to explain at least the tone of the debate and the message. And what does this have to do with, like, Medellin and bankruptcy? Well, the message that I take from those cases, as well as the other instances where the court and Congress and other constituencies have blended state and federal law, is that we do this all the time. Right, I know that international law is like, the stakes are different, right? You don't sort of have the supremacy clause to protect you like you do as a federal entity in the federalism situation. But the methodologies do have some analogy. That is, here we have the court in Medellin in the bankruptcy cases purporting to apply the law of another sovereign, the states, right, but maintaining very clear control. We can do it, right? And you can do it incrementally. You can do it without losing complete federal identity. You can do it with standards, right? So that, you sort of very slowly, allow that blending of sovereignties. So I'm not saying that these cases not represent any sort of wonderful judicial dialogue between sovereignties, but they do show that, in fact, the courts have tools that they've used for over 200 years that could be brought to bear in negotiating the challenges of global governance.
Good morning. I want to also thank the Law Review, the Law School and the University for bringing me here to participate in this symposium today. The invitation has provided me with at least one unanticipated benefit. We had a bit of an ice storm in Lawrence, Kansas on Monday, and I was bitterly complaining about the weather, but I will not complain about Kansas weather for a while, because by comparison, we're doing pretty well. I'm going to present to you an article, or summary of an article that I'm preparing with a colleague of mine, Rick Levy, for publication in this symposium. And we're going to suggest a framework in this article that we think would help courts decide what we're calling remedial preemption cases. And I won't even pretend to be stretching for elegance, but hopefully coherence will be an apt label to put on this. By remedial preemption, we mean preemption of state causes of action based usually, though not exclusively, on tort law, in which plaintiffs seek compensation for injuries they've suffered as a result of the defendant's activities, like manufacture of a product that the plaintiff used. And our focus is on ceiling preemption, that is, preemption of laws that are more stringent than federal laws. We believe that our framework achieves an appropriate accommodation of federal and state interests and promotes consistent application of preemption doctrine in remedial preemption cases. Our model or framework represents an extension or a new application of a model we first developed in an article published last year, where we used our approach to analyze whether the adoption of federal regulatory standards that restrict greenhouse gas emissions should preempt state regulation of those emissions. We recommend that courts considering preemption issues inquire whether the purposes behind Congress's decision to adopt a federal statutory program, instead of relying on state law to achieve relevant federal goals, support exclusive federal regulation. When we apply this approach to remedial preemption issues, we conclude that courts should be reluctant to interpret unclear express preemption clauses to cover state judicial remedies, or to infer remedial preemption from a statute that lacks an express preemption provision, unless, first, a primary purpose of the federal law, and here we're going back to what Bill referred to as a purpose-based approach, and David and Rod as well in the first panel. A primary purpose of the federal law is to promote the free movement of goods, prevent the export of regulatory burdens by downstream states, or solve a not-in-my-backyard problem. And in addition, there's strong evidence that state judicial remedies, as opposed to state positive regulation, would interfere with the achievement of those goals. Our approach to preemption analysis in health, safety, and environmental matters rests on several premises, some of which have been discussed earlier. First, we support the application of a strong presumption against preemption. The presumption reflects respect for state sovereignty, particularly when the federal statute addresses areas of traditional state concern, such as tort law. Our home state, Kansas, regards the availability of common law remedies to be so important that the state constitution explicitly recognizes a right of injured citizens to, quote, a remedy by due course of law, unquote. As a quasi-constitutional clear statement principle, the presumption is consistent with the view that courts should interpret statutes to avoid unnecessary intrusions on state sovereignty that might give rise to constitutional federalism questions. Finally, by requiring Congress to address the preemptive effects of statutes explicitly, which we think our approach will do, the presumption also reinforces the political safeguards of federalism that are built into the Constitution. Our second premise, and again here we're encouraging a purpose-based approach, preemption in all of its manifestations. How broadly should a court interpret an express statutory preemption provision? Did Congress intend to occupy a particular field of law that would frustrate federal statutory goals? In all of these areas, preemption turns on the purposes of federal law. Now, we recognize that statutes often reflect more than one purpose, but we're going to urge the courts to focus on purposes that were central to a statute's adoption. And third, we think that the determinative purposes for preemption cases should reflect analysis of what we're referring to as collective action problems. Those are problems that arise when a state has an incentive to act in a manner that's contrary to the interests of the nation as a whole. Congress often responds to these collective action problems by adopting legislation to counteract state incentives that push them toward solutions that are contrary to the national interest. We believe that displacement of state law is most justified when it results from the very incentives to diverge from the collective national interest that justified federal regulation in the first place. In regulatory areas, ceiling preemption is justified primarily when collective action principles suggest that states, and in particular for our purposes state courts, have incentives to overregulate, which need to be tempered by federal preemption. So what are these purposes that we're talking about? We identify 5 collective action problems that may justify federal regulation to promote health, safety, and environmental interests. And these are resource pooling, the race to the bottom, uniformity or rationalization of standards to lower transaction costs for regulated entities, externalities, and the so-called not in my backyard or NIMBY syndrome. Of these, neither resource pooling nor race to the bottom supports ceiling preemption generally, or ceiling remedial preemption in particular, because neither justification for federal action derives from a fear of overregulation by the states. Instead, in each of those 2 areas, the fear is that the states will underregulate. Uniformity, or a desire to reduce transaction costs for producers of nationally marketed goods or services by rationalizing regulatory standards, might support ceiling preemption. But concerns over diverse state standards are likely to be more troublesome in some contexts than in others. For example, multiple state standards are more likely to be problematic if they address goods that are mobile as opposed to goods or services that are stationary, like power plants. Our analysis suggests that ceiling preemption is likely to be most appropriate when states have incentives either to export regulatory burdens, that is, costs of regulation that are going to be borne by entities outside the state, or to overregulate an activity that exports benefits to another state. States whose businesses sell products nationwide may have incentives to underregulate because the undesirable health and safety effects of the products are primarily borne by people outside the state, while the economic benefits of the manufacturing process are concentrated internally. Collective action principles don't support ceiling preemption in that situation because ceiling preemption is designed to counteract overregulation by states whose interests diverge from those of the nation. But a state in which products are sold but not manufactured may have an incentive to overregulate because the resulting regulatory burden on manufacturers is going to be exported, borne by external entities, while the regulatory benefits are going to accrue within the state. In that situation, we're arguing ceiling preemption might be appropriate. The not in my backyard problem occurs if an activity such as a radioactive waste disposal site produces economic benefits that are exported to other states but causes health and safety burdens within the state. Here, states may have incentives to overregulate to keep the undesirable activity out, and ceiling preemption may be appropriate. So, assuming that collective action supports preemption, the next issue is whether the displaced state regulatory authority encompasses or should encompass judicial remedies. This is, picks up on David's point earlier that the statutory provisions usually refer to requirements, and the issue is whether requirements are meant to be limited to positive state regulations or whether they're meant to encompass judicial remedies as well. We argue here that there are important differences between state judicial remedies and other forms of state regulation that may make ceiling preemption of state judicial remedies less justifiable than preemption of positive regulation. And these include Differences between legislatures and courts as policy-making bodies, differences between legislative rules and judicial remedies as instruments of policy, and finally, the capacity to accommodate federal regulation within the structure of state remedial law. So, to amplify, legislatures and to a lesser extent agencies have incentives to adopt laws that favor their constituents. These incentives may lead them to adopt laws that export regulatory burdens because those who can benefit can vote, while those who are adversely affected are outside the state and have no input directly into the political process. That inclination may therefore lead to overregulation, which is a collective action concern that may support ceiling preemption. State courts, however, tend to be more insulated from the political process than either legislators or agency personnel tend to be. And state courts may be less concerned about being punished politically for their decisions, putting aside the relatively rare, controversial, high-profile decisions that occur in states with elected judiciaries. In addition, judges remain accountable to the law in ways that legislators are not, including precedent and the potential for reversal on appeal. These factors, we argue, suggest that courts in ceiling preemption cases should be cautious about assuming that Congress was concerned about the applicability of improper regulatory incentives to judicial decisions. They shouldn't find ceiling preemption unless there's specific evidence of congressional concern about judicial incentives. Mere general concern over state incentives shouldn't suffice to support ceiling preemption. What about the difference between legislative rules and judicial remedies as instruments of policy? The purposes and effects of legislative rules and judicial remedies differ. Most legislative rules focus primarily on controlling the conduct of regulated entities. Judicial remedies are meant primarily to compensate or provide other relief to a party who has suffered harm. Although, obviously, as Catherine said, there is a regulatory component to tort law as well. The availability of these compensatory remedies is rooted in the widespread perception that justice requires compensation when one person's wrongful conduct injures another. Courts should be particularly cautious, therefore, to find remedial preemption of state compensatory remedies if the preempting law doesn't provide some kind of substitute remedy for the state compensatory remedy that's being preempted. Legislative rules also have a more direct and significant impact on a class of entities than judicial rules tend to do. Judicial rules or decisions bind only the parties and may be distinguished in subsequent cases. They're less likely to have a direct, across-the-board regulatory impact on other entities than state legislative or agency rules will. A congressional goal of rationalizing standards to reduce transaction costs, for example, is likely to be upset more by a series of inconsistent state legislative rules than by the existence of tort liability in different state court systems, which can, by the way, be protected against by insurance. Finally, even if the language and purposes of a federal statute provide evidence to overcome the presumption against preemption, the complete displacement of state remedial authority often won't be necessary to accommodate federal purposes. First, it may be possible to make state remedial law compatible with federal law. Compliance with federal law might be treated as a defense to a state tort action if the lawsuit involves conduct that's regulated by the federal government. Or federal law could establish the liability standard so that state courts are able to compensate injured plaintiffs if federal law is violated. These approaches shouldn't compromise a federal interest in uniformity and rationalization of state regulatory standards because they retain the federal standard. The remedial standard is the same as the uniform federal regulatory standard. For the same reason, state remedies shouldn't create export of burdens or NIMBY problems. Second, even if one liability theory is preempted because of Congress's concern about avoiding collective action problems, other causes of action may pose no such problem. If a federal regulation gives product manufacturers two options for complying with a federal standard: put in airbags or put in passive restraints, allowing state courts to impose monetary liability on the basis of the manufacturer's choice to put in passive seatbelts instead of airbags could disrupt federal efforts to rationalize regulatory standards. But suppose instead that the plaintiff alleges that the same injury it suffered in the accident was caused by the manufacturer's defective design of another component in the same automobile, like a defective headrest, that's not covered by federal regulation. Allowing tort remedies in that case would not result in a similar disruption to a presumed congressional intent to rationalize regulatory standards. And so our end point is that both Congress and the courts should be cautious in creating or finding sealing preemption of state judicial remedies.
Melissa, when's
Well, I will try to be quite brief. I am quite aware that I am the last speaker separating you from lunch. Also, I note that some of my colleagues who have been here most of the morning have disappeared. One of them is my sometime co-author, Eric Jensen, and I don't want to provide too much evidence to confirm what inferences you might draw from their disappearance. We've been talking about federal preemption of state laws and legal claims based on state law. Many of the arguments relating to federal preemption have their counterparts at the state level, and I just want to spend a few minutes talking about that. At the state level, the debate tends to focus on the extent to which units of local government enjoy the latitude and autonomy to set their own rules and regulations. For a long time, the debate over home rule pitted cities against rural areas and cities against the state government. Today, with the rise of suburbs and even exurbs, the debate has become more complicated. But the arguments about the need for uniformity on the one hand and the importance of local autonomy to allow for experimentation and adaptation to serve the special needs of particular communities echo many of the arguments in the debate about federal preemption. The debate in the states has arisen in a variety of contexts, including efforts to promote local regulation of firearms and regulatory requirements for public employees. Because I have only a few minutes, I want to talk really about just one of those examples, and that involves municipal regulation of predatory lending. Those of you who know this area in particular know that that Cleveland has been a place that has suffered significantly from predatory lending. So let me just make a few kind of general comments about the framework of municipal authority, and then talk briefly about the way state courts have been addressing the efforts of cities to deal with predatory lending. Now, traditionally, cities had very limited authority. Under the influential Dillon's rule, basically municipalities could exercise only those powers that the state explicitly granted or that flowed by clear and necessary implication from explicit grants. And all doubts under Dillon's rule were resolved against the existence of municipal authority. The restrictive approach in Dillon's rule proved to be pretty controversial because many people believe that local autonomy promotes important social and political values, such as democratic participation, the adoption of public policies that take account of local needs and local opinion, promotes and enhances a sense of community, affords opportunities for reform and innovation that might not be possible at higher levels of government. Eventually, most states conferred some degree of home rule, but even when a unit of local government has home rule, the state might indeed preempt that authority. Now, since North Carolina adopted its pioneering predatory lending law about 10 years ago, about 20 cities and other units of local government have considered similar proposals. Almost all of these measures, all of the ones that passed, faced immediate legal challenges as well as efforts to obtain preemptive state legislation. Courts in New York, California, and Ohio, state supreme courts in those states, have actually dealt with these issues, and they have pretty much ruled against the local measures, although the situation in Ohio is a little more complicated. The lower courts were in some disarray. The state Supreme Court ultimately stepped in and resolved the conflict. Now, the first of the preemption cases came from New York, invalidated a New York City ordinance that forbade the city from doing business with predatory lenders. The New York court held that the state's banking law, which included specific provisions for dealing with high-cost loans, preempted the ordinance. Court used two familiar grounds to people who have been looking at the federal cases, conflict preemption and field preemption. Conflict preemption in that there were provisions of the local ordinance that differed from state law in some important respect. Field preemption in that the state had essentially occupied the field of predatory lending regulation, and therefore there was no room for local initiative. California Supreme Court, in a case involving an ordinance in Oakland, ruled that a state law that directly regulated home loans preempted the municipal law, and because the Oakland ordinance was stricter than the state law, the local ordinance had to give way. Now, if you read the case, it's a 4-3 decision. There's lots of debate between the two opinions about how to read legislative history, the statutory language, legislative intent. But in the end, the California Supreme Court came down against the city, and came down against the city even though the California Constitution has a very powerful home rule provision. Now, there have been a number of cases in Ohio. The first involved Dayton Ordinance, which the Regional Court of Appeals for that part of the state found to be preempted under an Ohio law. The city of Dayton actually sought a declaratory judgment that the state law interfered with the home rule powers given to municipalities under the state constitution. The Court of Appeals said not so fast. This is a general law, and under the applicable Ohio analysis, the court said the state law preempted the local ordinance. The City of Cleveland adopted its own predatory lending ordinance. Here, the local Court of Appeals upheld the measure and found that there was, in fact, a violation of the city's home rule authority. Meanwhile, another Court of Appeals, using a similar analysis to the one that the Cleveland court used, found that a Toledo ordinance was preempted because it read the record differently. Ultimately, the Ohio Supreme Court sided essentially with the Dayton court, held that the municipal governments do not, in fact, have the power to regulate, at least in a situation where, as in Ohio, the state legislature, largely at the behest, by the way, of the mortgage lending industry that had challenged all of these municipal ordinances, got the state legislature to pass legislation that the state Supreme Court ultimately concluded preempted the local ordinances. Now, to leave just a couple minutes for maybe some questions and discussion before lunch, let me try to wrap up at this point by noting that there are some differences between preemption of state laws and claims by the federal government and preemption of local initiatives by states. For one thing, states are sovereign, at least to some extent, in our federal system, whereas at the state level, units of local government are not. They are creatures of the state, and therefore the kinds of arguments about preemption and intergovernmental relations at the state level work a little differently than they do at the national level. Still, many of the issues that come up in the federal debate about preemption play out in similar ways at the state level. We have situations in which cities or other units of local government may want to make some kind of reform that because of concerns about uniformity, people do not want to have a patchwork of regulation. On the other hand, some of the issues that David Vladeck and the panelists on the first panel this morning indicated, the question about competence and capture, may also come into play. And I think that the history about predatory lending regulation in Ohio is a pretty good example of that. Well, this isn't a terribly profound observation, but I think it suggests that the whole question about authority and intergovernmental relations is more general, perhaps less glamorous when we think about it at the state and local level than when we think about it at the federal level. But I think we're dealing with many of the same sorts of issues. And with that, let me turn things back to Andra so that we can have a little discussion.
Thanks to our panel for 3 very, very interesting talks on some of the specific aspects of various areas of preemption. Any questions from the audience to any of our panelists?
So this is a question for Professor Glicksman, which is implicit in your framework. There has to be a decision maker, right, about what the purpose of the federal regulation is, as well as presumably what the purpose of the state tort either regulation or common law. And I wonder, it seems implicit, although you didn't discuss it, this is more just an invitation to discuss as an institutional matter, to what extent do we want to leave courts sort of on their own making those inquiries, or how would that come into your model?
Well, I guess the first thing I would say would be that if Congress really wants to preempt and make sure that its preemptive decrees are respected by the courts, it ought to create an express preemption clause that specifically defines the purpose of the federal regulation and the scope of the area that's going to be preempted as a result. And so Congress has the capacity to make it easy for the courts by explicitly stating what the purpose of the preemption provision is. Second, I guess I would say even where that doesn't happen, courts are capable of ferreting out principal and secondary purposes. And let me give you an example. There are 3 recent district court cases involving suits by auto companies to preempt or to declare invalid state regulations of greenhouse gas emissions patterned after California's standards. And one of the arguments that the auto companies made is that state regulations of this sort will interfere with the president's authority to conduct foreign affairs, because if the president wants to negotiate an international agreement in which other countries are willing to commit to greenhouse gas reductions, the best negotiating position for him would be if there's no regulation at either federal or state level, so the president can say, hey, we're not doing anything unless you agree. So there's got to be agreement all the way around, and absent that, sorry, we're just going to sit on our hands. The court rejected that argument in all 3 cases, and the rationale was that there was no evidence that the Clean Air Act was designed to maximize the president's bargaining power in foreign affairs. Instead, the Clean Air Act was designed to protect the environment and reduce health risks from exposure to air pollutants. And so even if there had been some purpose, I suspect the court would have found it to be subsidiary to the main purpose of the Clean Air Act, which is to clean up the nation's air. Anecdotally, there's some evidence that the courts got it right in those cases. I was talking to somebody who was at an international conference that took place in the first week of November on greenhouse gas emission reductions, and it was attended by not only NGOs but representatives of foreign governments. And the first 2 or 3 days of the conference, people were extremely glum, sitting around thinking that everything was hopeless. And then, you know, since it was, I think, in Europe, the news that Obama had won came over the news wires while the conference was occurring, and there was a spontaneous outburst of applause. And according to my friend, the conference was energized at that point. And the point is that the foreign countries knew that there was going to be a president who was willing to do something, and instead of the reaction being, well, instead of the foreign countries reacting to a situation in which the president is holding back and saying, we're not going to do anything until you do, the perception that Obama was willing to go forward made these foreign negotiators more willing to do something rather than less willing to do something. So that would be my response.
Yeah, I don't need the mic. I'm a big fan of purpose-based regulation, but this distinction between primary and secondary purpose might run afoul of that old Ackerman-Elliott theory of statutory evolution. The way you prevent Republicans from filibustering bills is you give them something in return, right? And typically what you give them in return is a preemption clause, a preemption possibility, a preemption something. And so it seems to me the secondary purpose is often what passes legislation. And so you can't downplay it and say, oh, that's just secondary. Somebody like Easterbrook would say, look, every statute's a bargain, and you got to respect both sides of the bargain. So you can't shuck off the secondary part, because that was a consideration for the bill. So what do you say to that?
I guess my response is the same, that Congress can avoid that by explicitly defining the scope of an express preemption clause and saying, this is what we're concerned about. We don't want the states doing this, and therefore we're going to prevent them from doing so.
Get it in writing.
Yeah, get it in writing.
I don't know if this is a question, but this is for Professor Little. It's like you mentioned about transnational and international principles coming into play in this, and I'm just wondering to what extent the courts, when they engage in preemption, are bowing down to or kowtowing to some of the bylaws of the WTO, where they tend to allow companies to race to the bottom and dump shoddy merchandise upon communities without any legal representation or or democratic participation.
The particular debate that I was referring to is actually the debate pertaining to the use of those principles in constitutional decision-making, United States constitutional decision-making. But the critique that integrating these principles undermines democracy also applies in that particular context. And I tend to think, as a general matter, in the context of judicial review of constitutional questions, that critique, it rings a little hollow, because after all, the context is one in which we've indulged, if you want to put it that way, we've indulged counter-majoritarian sentiments in any event, so that the idea that all of a sudden an important tool should be taken away from the courts because of concerns with democracy just doesn't have as much potence as it might in other contexts.
Great. Well, I think it's getting on time for lunch, so I'd like to thank all of our panelists once again for excellent presentations.